Welcome to the Divorce Lawyers podcast, brought to you by DivorceLawyers.ca, your trusted source for family and divorce law insights in Ontario, Canada. I'm Deepa Taylor. Today, we're diving deep into a critical topic in family law: best interests of the child, legal insights. In family law, the phrase best interests of the child is foundational. It's the guiding principle behind every decision made by the courts when it comes to issues involving children, whether it's custody, access, or parenting time. Today, we're going to explore what this term really means, the legal framework surrounding it, and how it's applied in practice here in Ontario. Let's start by understanding the basics. The concept of the best interests of the child is enshrined in Ontario's Children's Law Reform Act and has been further codified in the Federal Divorce Act. This principle ensures that any decision regarding a child prioritizes the child's well-being above all else. The courts are required to look at various factors, including the child's physical, emotional, and psychological needs when making decisions. But what does this look like in practice? The legal test for the best interests of the child involves a comprehensive analysis of several factors, each of which carries significant weight in the court's final decision. First, the court looks at the child's physical, emotional, and psychological safety. This doesn't just mean physical safety. It also includes the child's emotional and psychological well-being. For example, if one parent has a history of domestic violence, that would heavily impact their chances in a custody dispute. Next, the court considers the child's needs based on their age and stage of development. A toddler's needs differ greatly from those of a teenager, so the court will focus on who can provide the most stable environment for the child. The strength of the child's relationship with each parent is another critical factor. The court isn't just looking at the parents themselves, but also at relationships the child has with siblings, grandparents, and other important people in their life. Continuity and stability in these relationships are key considerations. Family violence is an area where the courts take a serious and protective stance. Under the Divorce Act, the court is required to take into account any history of family violence when deciding what is in the child's best interests. Family violence doesn't just refer to physical abuse, but can also include emotional, psychological, and even financial abuse. For example, if one parent has been using coercive control over the other, or the child, the court might limit that parent's time with the child, or impose supervised access conditions. The court also evaluates each parent's willingness to support the child's relationship with the other parent. This involves looking at how well parents communicate and cooperate for the child's benefit. If a parent is undermining the child's relationship with the other parent, that could hurt their case in court. Another area of focus is the parent's ability to work together on matters like schooling, medical care, and extracurricular activities. High-conflict parents are often encouraged to use communication tools like Our Family Wizard to help manage these issues. As children get older, their own views and preferences start to carry more weight in the court's decisions. In Ontario, especially as children approach their teenage years, the court may take into account what the child wants, but this is balanced against their maturity and understanding of the situation. For instance, if a 14-year-old consistently expresses a preference to live with one parent, the court will consider that, but they'll also look at the reasons behind that choice. Is the child making that decision because they feel safer with one parent, or simply because that parent is more lenient? The court also considers the child's cultural, religious, and linguistic background. This is particularly important in a diverse province like Ontario, where many children come from multicultural families. The court wants to make sure the child's heritage is respected and maintained, and this might affect decisions about where the child will live or which school they'll attend. Finally, if a parent has a criminal record or is involved in ongoing civil proceedings, the court will factor that into its decision-making process. For example, if one parent has a history of substance abuse or criminal charges related to that, it will likely weigh against them when determining custody. In conclusion, the best interests of the child is not just a legal phrase. It's a comprehensive approach that the courts take very seriously. Every factor is weighed carefully, with the ultimate goal of ensuring the child's well-being is the top priority. For parents going through a separation or divorce, understanding these factors is key to navigating the legal process successfully. For personalized guidance, please consult one of our family lawyers by visiting DivorceLawyers.ca. Thank you for joining me on this episode of the Divorce Lawyers podcast. If you found this discussion helpful, please consider subscribing to our podcast and leaving a review. Your feedback helps us continue to provide valuable content. Until next time, take care and remember, when it comes to family law, it's all about what's best for the children.